Welcome to the Cook Group's podcast, What's Cooking in Litigation, with your host, Brian Wacker. In each episode, you'll meet industry leaders, innovators, and educators in litigation. We'll discuss the latest advancements, efficient practices, and strategic updates. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, cookgrouplegal.com. Now here's the host of What's Cooking in Litigation, Brian Wacker.
Hello and welcome to What's Cooking in Litigation. I am your host, Brian Wacker. We are back for our fourth episode. Each week we are going to be breaking down trends in litigation and chatting with some of the folks we think are the sharpest minds in the industry, and including those within our own firm, the Cook Group. Now, we've spent the last few weeks getting to know folks in different offices in the Cook Group, and we're rounding it out today with our newest partner in the Cook Group, Christine Calareso, our managing partner in our West Coast office. Christine, welcome.
Hi, thank you so much for having me.
Christine, this is my chance to get to know you as well as everybody else. You and I have met briefly at our partners meeting earlier this year, but I'm curious. I want to know more. Can you give us a little bit of your background and how you got to this point?
Sure. So I went to law school in Washington, D.C., and at the end of law school, was newly single, and a friend of mine called and said, "Do you want to move to California and date celebrities?" And I said, "I do want to do that. I do want to do that." And so, you're 25, you think everything is easy. And so I was like, well, how hard can the California bar be? And so instead of taking the Maryland to DC bar, I took the California bar, and we moved with zero money and zero plans and not a clue. And we just moved to Los Angeles and thought that we had made it. And you don't get your bar result. Right, exactly. So you don't get your bar results until Thanksgiving. So your Thanksgiving is either like really great or really terrible. And we moved in August. So I didn't have a job. I didn't know if I passed the bar. And so I needed to pay rent. And the first job I got was as a paralegal, I guess, in a toxic tort firm doing litigation. And I thought, this is pretty interesting. And once I got sworn in, that afternoon I went to a deposition, and the next day I was arguing motions, and just kind of fell into it, but really liked the variety, and liked being in the courtroom, and liked meeting all sorts of different people and just getting so much experience. So I had friends that were, at bigger firms, certainly making much more money than I was, but had been working for years and years and years and had never seen anything other than the basement full of documents. That's all they had ever done. And so found my way to Orange County and have worked for a couple of firms. And I'm just delighted to join the Cook Group with my team and clients and represent you all on the West Coast. So here we are 23 years later. And I'm still in this litigation.
We're thrilled to have you. Can you tell us a little bit more about the team that you just referenced and
Sure.
what it is we're able to offer over there?
Yeah, absolutely. So I have been working with some of these people for really almost 20 years at a couple of different firms, and we've really stuck together. And I hate to use the word family because it's a business. It's not a family, but these are people that are very, very near and dear to my heart. They work so well. They're just constantly curious about learning the next thing, learning the next strategy. So we have a group of paralegals and attorneys, a trial attorney, and just really people who like the litigation, but we like each other. But we're always looking to, just do better with every case and take what we've learned from other cases. So it's less about pushing paper. It's less about just, okay, this is the same old, and we really like to approach all the cases differently. And so we're really having a nice time.
Right.
So,
well, I as the resident mayor of flyover country here in Missouri, we hear all manner of things about California law, whether it's how onerous the bar is, or how there are these difficult jurisdictions, specific jurisdictions to deal with, or various statutes and propositions that sometimes are kind of foreign to anybody else who's not out there. What are some of the sort of the hot spots or areas in California, at least, that you do a lot of work in, and that we need to be sort of aware of?
Absolutely. So I'm embarrassed to say I probably could not pick out Missouri on a map, but I definitely hope to meet you someday. And the arch behind you seems very cool. I don't really know what it's for, but it does look cool.
I couldn't pick it out either. So don't worry.
And actually, so a little secret about the bar, just because you brought it up in terms of it being hard. It was one of the only states where you could actually take the bar if you went to a non-accredited law school, so that you could, just keep paying the funds to California and keep taking the bar. So most states, you actually have to go to an ABA law school or accredited law school. And in California,
I may be revealing too much about what I see in headlines, but is this the Kim Kardashian?
That came way later.
Okay.
Later. Now you don't even really have to go to law school. You just become Kardashian and hang out in an office for a while. But anyway, so that's the thing. So I don't want to downplay it because it really was hard, but the pass rate is so low because you could go to literally Joe Schmo University online and you can take the bar, but you're never going to pass. Anyway, that's just that. So California is a big state, as you know, and Los Angeles it's almost like a state within a state. So the primary litigation, at least for our purposes, for toxic tort and really even class actions and things, it's consolidated in Los Angeles County, which is huge, right? So Los Angeles County can be Pasadena. It can also be Santa Monica. It could also be down to Pomona. So if you've seen any of these things in the news, they're huge, right? I mean, so there's Los Angeles County, and it's coordinated with Orange County, which is just the county south of Los Angeles County, and also San Diego County, which is the lowest county. You don't go any lower because then you hit Mexico, right? Yeah. So it's Los Angeles, Orange County, San Diego. So when we say the words LAOSD, sometimes we'll use those acronyms like LAOSD interrogatories or LAOSD orders or something. It means Los Angeles, Orange County, San Diego. So that's south. North is Alameda County. That's sort of the second most voluminous county where cases get filed. And that's Oakland, right? So that's former Warriors, where the Warriors played.
Right. Cross the
right. Now they're in San Francisco. Okay. And then we have San Francisco. And San Francisco County used to be where you would park a lot of asbestosis cases, non-malignant cases that move a lot more slowly. So if you had a case that was not that high value, it might be in San Francisco, whereas the more high value cases might be in Alameda or Los Angeles. It used to be where certain firms were very dedicated to one particular jurisdiction or another, and that's really changed. Now you have the firms filing all over the place, and the Alameda has its own coordinating judge with its own interrogatories. They're generally called the deed-in interrogatories, or the standard interrogatories that you have to answer. San Francisco has its own interrogatories. And then the LAOSD has its own interrogatory. So there's basically, if you think of it, there's just 3 areas of concentration, 3 coordinating judges for each of those jurisdictions. And then they see these cases all the way up to really until they get kind of sent out for trial. And in LA, you could get sent out to anywhere in Los Angeles County, which might as well be another state.
This is where you're going to terrify me, because you and I spoke about this briefly last week. And is it true, and is this just Los Angeles County, or is this everywhere, that you won't know physically where your trial is until the day of trial?
That's exactly right. So you'll basically report on the first day of trial, you will report to Department 1, which is in downtown Los Angeles. And they kind of do like a Wheel of Fortune wheel. Okay, who, which judge is open right now? And a lot of these cases are preference cases. So that's kind of another issue we have. You talk about the rocket docket. If you're over 70 years old, or there's the likelihood that you're going to pass away within 6 months, you get a trial date basically within 120 days. So our case, and statutorily, you can only continue it one time for 2 weeks. So they're moving. So you have to kind of see what judge can handle a 30 or 45 or 60-day trial that has to go out now, right? And so depending on where you get sent out, then that judge will order you, you get kind of a minute to decide if you're actually going to challenge the judge. You do get like one shot to challenge a judge on each side. And then you might be in a much more conservative county, or not county, but area courthouse with different kinds of jurors. So it's really important to know as an attorney so that you can advise your clients. It's incredibly important to know, okay, if we get sent here and a challenge has already been used or something like that, this case may have a different value. This case is going to have a different kind of jury. So Los Angeles is an incredibly diverse jurisdiction. So you're going to have differences. It's almost like being in another state, depending on where you are in LA.
I remember one of my earlier managing partners who, one of the few that were nice enough to talk to me, had always said when you start a case, the most important things to know are the local rules and the jury pool. You can think you know everything else about all the state law, and you may have the greatest briefing talent in the world, but if you don't know the local rules and the jury pool, you can get burned very badly.
Yeah,
sounds like
100%. 100%. You really do. And a lot of judges that are, they may only see an asbestos case. They're only going to see an asbestos case if they're trying the case, if they're the trial judge, because all of our cases, as soon as they get filed under one number, right? And then they go with one judge. So these other judges aren't going to have a ton of, face time with asbestos cases. So really half the battle is educating them even on the first day, like, how do these cases run and what's going on? But it's really important. I think this is where, it's kind of embarrassing that I've been doing this for 23 years, and that means that I'm old. But I've been able to understand now, okay, I know exactly if you say we're going to Pomona, I can tell you what kind of jury that's going to be. If we're going to Santa Monica, I can tell you what kind of jury that's going to be, and on, because they are different, and you just have to kind of keep up with it and take notes and learn from, how the other cases go with the judges. And every single judge is going to have a local, or what we call local rules. So, right, you're, make friends with the clerk. Don't come in and act like everything because, you're in asbestos litigation. You're probably already going to get looked down on, because they're going to see a 30 or 60-day trial and be like, what's happening? And then half of the time they'll just send you to a settlement conference because they don't want to deal with you. Or they'll say, we're not really going to start for a week. And then some of them will say, hey, you report back this afternoon and we're going to do motions in limine, or we're going to start hardshipping jurors or something like that. So you really don't know, you're on your toes. And I don't try cases, I negotiate cases, but that's where it becomes very important for me to be able to advise clients, hey, we're in this area now with this kind of judge, with this jury pool. This is how things have changed for the better, or for the worse. And this is what we should do accordingly.
Well, so you said two things there that also put a light scare into me. Not that I practice in the most business friendly environment here in St. Louis and Southern Illinois, but so is it true then that your pre-trial, any motions that you have or anything that you really need to get to narrow the issues for trial, are those handled by your trial judge, or are they handled beforehand, or do you even know?
A lot of times they are handled by the coordinating judge, but sometimes very unique ones might get asked to be ruled upon by the trial judge. So, the classic, it depends. It depends on the case. It depends on the issue. If you're having kind of the standard run of the mill motions in limine, they might just stay, the coordinating judge might just decide to hang on to those and rule on those. But the parties and the judge can also decide that a trial judge is going to handle certain ones, especially if it affects the timing of a trial or if there's a bifurcation or things like that.
Yeah. So you said, and I can't believe that would be the case with seeing you, but you said you've been practicing for 23 years. I've been practicing for about 17, and I think for about 16 of those, I've been told that toxic tort litigation and asbestos litigation is waning and it's on its way out, that it's going to die, and that we all need to find other jobs.
Yes.
Is that the case out in California?
So when I was probably 2 years out then, and I had been doing it, and someone had said, you need to get out of this litigation. It's going to dry up. It's not going to, and because toxic tort really follows its own rules, right? So yes, you have to generally follow the rules of civil procedure, California civil procedure. You also then have rules that were created by all of these different judges in these jurisdictions. So you have a set of rules for LAOSD, you have a set of rules for Alameda, you have a set of rules for San Francisco that govern a variety of things, right? So I left asbestos for a few years and went to a firm where I did all sorts of general liability, big giant accidents, fires. I represented Macy's, where they had false imprisonment kind of claims, usually like with shoplifters, again, giant catastrophic accidents and things like that. I learned how to do the code, right? I learned how to practice law according to regular law. And then someone got word at the firm that like I knew how to do asbestos litigation. And all of a sudden I got right back in. So
it's the line from The Godfather. It brings you back in.
You can't get away. And then there's been different iterations of it, but there's been sort of a lot of benzene litigation. Now there's silica litigation, which I don't think is actually going to last that long, just because the carriers or the insurance doesn't usually cover those cases. So unfortunately, I predict a wave of bankrupt entities, and then it'll kind of fizzle out. Yeah. But now you have talc litigation, right? And so you have pure talc litigation, and then you have asbestos related talc litigation. So there's iterations, but there's still, this is the way I explain it to friends who are like, I don't know what asbestos is. Wasn't that banned a million years ago? What's going on? I see these commercials. There's still only about 3,000 diagnoses of mesothelioma a year. Still very rare, right? But 99.9% of all of those diagnoses turn into a lawsuit.
Right.
That's why it's so much. It's not like it's going up exponentially, although I would say ovarian cancers are going up and other kinds of cancers are just going up for a variety of ways. That can be another episode. But for mesothelioma, which is the signature, asbestos related disease, it's still the same. But when you type in asbestos, the first thing that comes up is 4,700 pages of attorney ads. Right. And so if you have every single diagnosis turned into litigation, then it's going to send all of our kids to college. I mean, so we're still in it.
Yeah, because we've, our jurisdictions here in the Midwest, it's often more volume centered, right? There's the cases, there are a lot of efficiencies in our local rules that allow for that, where a certain firm could maintain hundreds and hundreds of cases at a given time, but they're always there, and the numbers haven't decreased. They haven't even flatlined to that. I mean, the all of the premature sort of declarations of the death of that industry, they just haven't come to fruition. And then now I think it led into the last thing I want to ask you about is talc litigation, right? So we're starting to see a lot of what I would call these sort of hybrid cases in the Midwest, where you have allegations of not only workplace exposure, take-home exposure, et cetera, but now there's these folks who have alleged that they have lifelong talc use. And I think it seems to be, at least in the Midwest, and I'd ask if it's the same way in California, sort of a burgeoning sort of style of case that maybe the plaintiff's bar is, still putting their feet in the shallow end to see, hey, is this going to be something that lasts for a while?
Absolutely. Absolutely. And when you've got, so we're seeing, ovarian cancer claims, right, that are sort of like from direct, the allegation is sort of direct exposure on different areas of the body, especially, private areas, and then that can lead to cancer. And just the essence of the talc, the way the talc is structured and whatever causes a disease. And so, in your backyard, there was a $4 billion verdict by Mark Lanier, and
right.
it had 22 plaintiffs and all of that, and all of them had ovarian cancer. And that really, that was a huge case. So it put a lot of talc suppliers, talc manufacturers, anyone sort of directly tied to that, it put them in the crosshairs. And as the larger companies start deciding, okay, well, either we're bankrupt or we're going to set up a trust, then more and more plaintiffs have to find additional parties to bring in. So there's ovarian, but then there's also mesothelioma cases that, they're using body powder and they allege that they're breathing it in and that it was contaminated with asbestos. But then you're doing really deep dives into medical issues. You're doing deep dives into really where is it being mined,
Right.
and all of that. And then trying to get past certain legal standards as to, okay, who's got the burden of proof? Because you can't do a market share theory. You can't just say, well, you had 10% of the market share, so it must have been yours.
Right.
It's not that onerous in California. You still have some defenses, but especially with a lot of the female plaintiffs, and different parts of California are really hot, right? And people use body powder because it's hot and to prevent sweating and to prevent chafing and all of that.
Right.
So it's not, you can't really, it's a lot harder to push against some of the allegations because it's perfectly reasonable to say, yes, somebody used body powder because for whatever reason, they live in the desert and it's really hot. And I think the issue with that is that most jurors, I think, can understand that. They can visualize that in a way that is different than trying to have to visualize what's going on in a naval ship.
Right.
What is going on with a brake repair? What is right? Those are a little bit more difficult to get across in terms of what's actually going on. People might not have done that, but almost everybody universally has either used powder or used it on a baby or seen it or seen some sort of representation. And so that is something that definitely presents a challenge when you're on the defense side because it's something that's so ubiquitous. And you also want to tread carefully. You want to tread carefully. You don't want to start calling everyone a liar and being disrespectful and all of that, especially if it's women, especially if it's younger women. And those can be very, very, very problematic cases for sure. And those we're seeing tons of them being filed.
Right. Well, to sort of wrap it up, now that you've sufficiently scared me as a defense lawyer and a small business owner as to the state of California, I'm sure there's a silver lining, or there's some good things you can tell us about it in terms of if you have good representation, how that sort of world can be navigated.
Yeah, absolutely. I think the biggest thing is there is something to be said for doing this litigation for a long time. It's not something to be embarrassed about. Oh, I'm still in asbestos litigation. It's something actually to be proud of. Oh, I'm still in this litigation, which means I have seen all of the iterations of plaintiffs' firms and who came from here. And I know that person from wherever, because as much as defense attorneys also move firms and switch around, plaintiffs do the same thing. So we've seen the creation of a lot of new plaintiffs firms that are breakaway little teams from other plaintiffs firms. So these are all familiar. They're just different packaging, right? So now I know, oh, okay, that person, I dealt with you when you were at XYZ firm, and now you're here, and I know what you're really good at, and I know what you're not good at. And so I think if you're sort of jumping in from the outside, most of it, or a lot of it, I should say, is the relationships that you have and the understanding of the inner workings and some of that institutional knowledge from decades ago. And I will say this: the defense bar works pretty well together. There's always room for improvement, but we have meetings. We can share information. We know what's going on, and there definitely are. There are definitely more and more cases that are not being granted preference or an expedited trial just because. So the judges, are they overall, would I say, lean a little bit towards the plaintiffs? Of course.
Yeah.
They're all lovely judges. They're all great, but it's not as rubber stamped, I think, as it's a pendulum, right? Sometimes it's like every single case, no matter what, got an expedited trial date, and sometimes it goes back. But you can still prevail on summary judgment. You can still, take a really good deposition. You can still really, access to a lot of documents. We have really good experts, and we have good co-defendants amongst each other. And so I think it's just really wise for clients to hire counsel that do know all of the inner workings of the court system, the jury system, the plaintiff's bar, and the defense bar, and kind of how it all fits together. And I will say, I mean, this is of course a shameless plug for our firm, because this is our podcast, right? We're going to say whatever. But knowing also what certain clients are dealing with in other jurisdictions, because plaintiffs have offices often in other jurisdictions.
Right.
So it's really important to say, okay, well, what have you been going through in St. Louis? What have you been going through in, NICAL? What have you been going through in, Chicago and Philadelphia and some of these other, quote, hellholes? And taking a unified approach in what you do, I think, is really beneficial for the client to really have the 10,000 foot view of what is really going on here, so that we're not chasing things that we shouldn't be chasing, that we're not wasting time where we should waste time. Can we group cases together when it makes sense? Only, and then don't let the plaintiffs, put or, pit one office against each other.
Right.
Because we don't want to play those games, right? So whatever games they have going on, with credit and all of that, we're not interested in playing those games.
Yeah.
So it's really nice. And I've been delighted to be here over the last few months and join you guys. You guys have been so wonderful to work with, but it's really great to have so much experience across these problem jurisdictions so that we can solve problems together and not just, stay really pigeonholed into one jurisdiction.
Right. No, I mean, for my part, we're thrilled to have you. We're thrilled to have the West Coast presence that we've been looking for so long. But I think everything you said just there is so translatable to all facets of litigation. Doesn't have to be asbestos or talc or anything. Relationships, knowledge of local rules, the local folks, knowledge of the courts, and just having a good 10,000 foot strategy at all times, and knowing that we're objective driven, and that ultimately we're just trying to get the best result here. And how we get it, sometimes it's different, but I think everything you said there it could be put on a plaque for any young attorney in any practice. So, well, Christine, we've hit our time. I really appreciate you coming on, and thanks for joining us. I'm sure we will get you back on. You've got a wealth of knowledge that I think we're just tapping into. So thanks for joining us today. Thanks,
Brian. I appreciate it. This was fun.
All right. And that is it for our latest episode of What's Cooking in Litigation. Again, thanks for tuning in, and please be sure to subscribe on YouTube and anywhere you get your podcast. Hit that like button and share it with anybody that you think may have some interest. And we will see you in a couple weeks. Stay informed and take care. All right. Bye-bye.
Okay.
You've been tuning in to the Cook Group's podcast, What's Cookin' in Litigation, with your host, Brian Wacker. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, cookgrouplegal.com. Thank you for sharing this show with others.